Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. In a world of contracts, one case changed everything. Join me as we unravel the landmark story of Taylor v. Caldwell and discover how a single event reshaped contract law forever. Ready to learn? All right, let's paint a picture. It's 1861, and two men, Taylor and Caldwell, are about to make a deal that will change English contract law forever. Taylor, an ambitious concert promoter, wants to host 4 epic concerts at Surrey Gardens Music Hall, which just so happens to be owned by Caldwell. They put pen to paper, sign a contract, and everything is set. Or so they think. But here's where things get interesting. Before the first note is played, disaster strikes. The music hall burns down in a freak fire. Imagine that feeling. You're Taylor, you've sold tickets, hired musicians, maybe even told your friends to come watch. And now, there's no music hall left. Caldwell can't host, Taylor can't perform. So what happens to the contract? Taylor says, "Hey Caldwell, I still had to pay everyone back. You owe me for breaking the contract." Caldwell, on the other hand, insists, "Look, the hall is gone. It's not my fault. How could I possibly deliver on this?" This dispute lands in court, and the judges have to decide. When something unexpected and out of both parties' control destroys the very thing the contract depends on, is the deal still binding? Or can both sides walk away? Enter the Doctrine of Frustration. This case is famous because the court, led by Judge Blackburn, essentially writes the rulebook. He says, if the subject matter of a contract, like the music hall here, is destroyed through no fault of either party, the contract is automatically ended. Nobody's to blame. Nobody has to pay up. It's as if the deal never even happened. This was a huge shift from the old rules, where contracts were sacred and parties were held to their word, no matter what. Before Taylor v. Caldwell, if a contract became impossible to perform, tough luck. You still had to pay damages. But thanks to this case, English law recognized that sometimes life just throws you a curveball. The Doctrine of Frustration now covers all sorts of unexpected events, from fires to floods. It's about fairness. If neither side is at fault, why should one suffer more than the other? Taylor v. Caldwell set the stage for how courts handle these situations even today. So next time you see a contract, think of Taylor and Caldwell. And remember, sometimes even the best laid plans can go up in smoke. The key is, the law's got your back, as long as you're not the one lighting the match. Thanks for watching. I hope you enjoyed the story behind the case. Please like, comment, and subscribe for more legal cases made simple.